This is Paul Turner, the Immigration Barrister at Imperium Chambers. Please subscribe to my channel and hit the notification button for all immigration news, whether that be cases, Home Office policies or anything relevant. Good news to report today is the Court of Appeal quashed the false identity conviction for a failed asylum seeker, clearing the path for him to apply for British citizenship. This is an excellent result. In short, the applicant had been prosecuted for using a false passport to enter the United Kingdom, which would normally be a bar to obtaining British citizenship, or could be, but yet he still managed to obtain his British citizenship. This applies to a few people, a few clients I've had, and if you've had any problems in the past, this case shows that the door to British citizenship is not closed to you. Given how important this case is, it is worth going through what took place in court, and what the outcome was and why. The Court of Appeals I've mentioned quashed the conviction in the case of a failed asylum seeker who'd been found guilty of possessing a false identity document in what is a pretty dramatic and fantastic win for the principle of justice in such cases. The particular name of the case, should you want to look up it, is a case of Mr. Elmi. I hope I pronounced his name right. He had been prosecuted for using a false passport when trying to enter the United Kingdom. He claimed asylum the following day, but was charged with using the fake passport and was sent before the Crown Court. At the time of his hearing, he had not been advised, this is before the Crown Court, on a defence of him being a presumptive refugee under Section 31 of the Immigration and Asylum Act 1999. He therefore, on probably poor advice from the criminal solicitor, pleaded guilty to the charge and was sentenced to 12 months imprisonment. Mr. Elmi's asylum claim was refused and a deportation order was signed against him. He appealed to the First Tier Tribunal, and although he was not successful and considered to be a refugee, he was granted humanitarian protection on the basis that he was at serious risk of harm if he was returned to his native country, and his Article 3 and Article 8 rights would be breached. The issue in this particular case was that had Mr. Elmi been advised that he had a legitimate defence, then he would not have pleaded guilty to possessing a false passport, thereby triggering the course of action where he would forever be viewed as having bad character. Mr. Elmi had, by virtue of the bad advice, become a convicted criminal, and his conviction stood in the way of his path to citizenship. He was unable to work in certain jobs, get a mortgage, and in short was dealt an injustice by the legal system that was meant to protect him. In an attempt to rectify or justify the injustice, the prosecution put forward the argument that Mr. Elmi's defence would not have succeeded, as he was later found not to be a refugee when his claim was decided 2 years later. The Court of Appeal, however, found that the decision to refuse Mr. Elmi's asylum claim would not have helped the jury at the time of his criminal trial. At the very least, the jury in Mr. Elmi's trial would not have been able to say that his case for claiming asylum was not untrue. It had not been considered. They found that there had been a clear injustice in his conviction and that the subsequent refusal of his asylum claim did not rectify this defence, which was runnable in court. This is a great result, as it shows that the Court of Appeal will call out such historical injustices and not entertain attempts to dismiss them by referring on what happened after the event, such as his asylum claim was dismissed. The defence was that if you claimed asylum, you have a defence for possessing a false passport. You don't have to prove that you're an asylum seeker to run such a defence. Indeed, given the huge backlog of cases, which I think is over 101,000 now, people would be waiting a very, very long time if that was the case. The case goes to show that in a more common sense scenario that's been seen in this particular case, where citizenship is refused on good character grounds, it may be worth digging a bit deeper to see if there has been an historical injustice in your case. If you think you have been affected or you've been unfairly prejudiced by something that happened in the past, then it is worth seeking the advice of a reputable immigration lawyer, or you can contact me. That's not to say that I'm irreputable, but you can always contact me if you want some help on this particular matter. It's a good win. It shows that things that happened in the past due to poor legal advice do not necessarily bar you from becoming a British citizen in the future. I hope this video it has been enlightening. I hope it's not been too boring. It's useful to dig into cases now and then because that's how the law is set in this country. Please subscribe to my channel again. Thank you very much for watching. Please stay safe. This is Paul Turner, the Immigration Barrister at Imperium Chambers.